to introduce this topic, we have our keynote speaker for this session, Professor Daniel Brinks from the University of Texas at Austin. And Professor Brinks has been part of the LawTransform community and the Bergen exchanges since the very start, 8 years ago. And he is one of the foremost experts on autocratic dynamics and democracy in Latin America in particular, but also in terms of thinking about it theoretically. And once Dan Brinks has finished his keynote, there will be a roundtable of excellent experts from across regions. And to moderate the panel is my colleague, Alida Steigler, who will then take over once Dan Brinks has finished the lecture. So without more ado, I will give the floor, the digital floor, to Dan, please.
Thank you. I'm not sure if somebody's supposed to turn on my video because I can't do it on my own. Oh, there we go. All right. Well, thank you again. Thank you, Sidi, and thank you to the rest of you for inviting me to join you this, well, it's morning for me, this afternoon for you. It was a little bit sad and nostalgic to see the room with some scattered chairs in it and a few people when we're so used to seeing it crowded and full of bustle and activity. And I really wish I could be there with you. But I do think this is a great opportunity to introduce a project that we've worked on together. Let me put up a PowerPoint to see how that goes. I don't know if hopefully someone will let me know if you can't see that. Let me just make sure I can get my, this is obscuring my video, so I want to make sure I can see if people post something in the chat. So I should be able to see the chat now. If someone has a question as I go along, feel free to post something in the chat or anything else. And I can't hear you, so for the most part. So, but do interrupt me if you think there's something I need to clarify. Anyway, the project that I'm going to be talking about today, this Autocratic Legalism project, came about mostly because we were seeing things happening out in the real world. And we had a number of conversations, I think prompted initially by Sidi and some others. And the last time we went round and round about this, the various partners on this project, you can see them listed there on my screen, were hugely important in helping us think through all the issues. And since then, I've been thinking a little bit more about it, and I may say things today that they may or may not agree with. And so hopefully we'll have an interesting conversation about that. But let me show you something so that I saw in the papers this Friday. So I was reading the New York Times on Friday, and I came across this article, this headline, UK scandals showing a system rife with insider ties, which, I don't know, maybe that's not news to you, but what caught my eye was the subtitle, the heading underneath, which says that for years, Britain relied on an informal code of gentlemen's agreements, and that informal code had fallen apart. And even more interesting for purposes of this project was one of the early paragraphs in the article said, here's this massive issue we have, or we're very worried about all these practices that are taking place out in our polity, but it looks like no laws or rules have been violated. One of the interesting things that they refer to is this idea that the system itself has too few checks and balances to prevent such behavior. And then they have a little bit of a diagnosis in the article, and they say, well, one reason we might be in this in this problem is that the conservatives wield enormous legislative power. They have a large majority. So that creates two problems, one that they mention in the next sentence and one that they don't mention, right? So the problem they mention is that if they control access to decisions, they control access.
Dan,
yes.
And so we can't see your slides.
You can't see my slides?
No, we can't see your slides.
Okay.
Have you been able to? You're sharing them, so you see them.
Okay, let me try again. All right, let me try again one more time.
Otherwise, you could probably send them to.
I have everything is sort of blanked out. So hang on, let me try.
You can send it to Alida, and she will make sure that it's shared. Or to me if it's easier.
Okay, well, it says all panelists can share.
Yeah.
Oh, I see. My system preferences were set so that it was not allowing
Is it on your side?
Yeah, the problem is on my side, but I think I'm fixing it. So give me 1 second.
Okay, good.
Sorry. And now I have to log in and do all sorts of things. Part of the problem is, as most of us, I haven't been in my office very much. So, and now I'm using, I'm sorry. All right. Okay, it says I have to quit Zoom to have it work. So maybe, so could I quit Zoom?
Maybe just send us the, maybe just send us the slides if you want them, or just talk without slides. No, he left. So we just okay. So another question.
Okay, can you hear me?
We can hear you and we can see the slides.
Okay, but now I'm prevented from starting the video because the host has stopped it, it says. So maybe you can give me permission to start the video now. But in any event, I mean, I can get going with this while you get the video sorted out. Anyway, so here are my here are my fellow authors on this project listed now for you to see on the screen. And again, I think many of them will have really interesting things to say from the perspective of their countries and their regions and so on. And hopefully I'll be able to set the set the scene for that a little bit. So here's the headline in the New York Times, and the mention to the fact that these troubling practices are happening even within the law. And here's, I think, as far as I'd gotten with this diagnosis, which is conservatives hold a lot of power. They're not so, and that means that they control access to government, they control access to policy decisions and resources as well, of course. And then the other problem, I think, that they don't mention in the article is that they're not really subject to effective checks, political checks, right? So when political power is that concentrated, then we tend to rely on non-political checks on their behavior, and that would require law to operate. And the problem is law doesn't apply or doesn't forbid these practices, and the unofficial codes that restrained earlier politicians, the norms of political behavior that people saw as effective, don't seem to work now in this context. So they blame Mr. Johnson and his unorthodox career. But ultimately, the question is then, Ms. White is a researcher from the UK, and she says, if the problem is that it feels wrong to us, but it's not actually wrong under the system, does that mean the system is not fit for purpose? And that, in a way, is the question before us in this project, right? Are the systems that we've relied on for so long to protect our democracy, to protect democratic practices within our countries, is that system now no longer fit for purpose? Is it no longer adequate to protect democracy? So we've defined the problem, the thing that we're interested in, the sort of autocratic legalism, the core of autocratic legalism, is not quite the same as what we saw in that article, not quite just insider deals and influence peddling and even corruption, although corruption obviously has a part in this, but something that really ties back to the very definition of democracy, the core practices that we require in a democracy. And we say those are three things: inclusion, right? Not excluding groups or particular people; participation, which means you have the right to run for office, but also that you can participate in political deliberation and debate beyond just running for office. And a basic set of civil and political rights, which are usually the underpinning for these first two practices. And obviously, we've seen lots of behavior in the past in different countries at different times that violates these three core tenets of democracy. But what we think we see now, as Siri mentioned a few moments ago, is that we see violations of these three core tenets of democracy that are completely legal and that are sort of legitimized or at least, argumentatively defended using the language of law, right? So people will say, well, we're entitled to do that, or that's we're actually advancing the rule of law. For example, in my country, in my state, in Texas, there's been an all-out assault on voting rights, right? And that assault on voting rights is not only done within the confines of the law, but justified as an attempt to protect the system from illegal voting, right? Even though we know that there's not really a problem that needs to be solved. So how does that happen? How can it happen that we're taking steps in a really autocratic direction without actually breaking any of the rules, of a democracy? Well, one of the premises of this project is that every democracy is necessarily under-institutionalized. That actually, just as that article mentioned for the UK, every democracy depends on informal institutions. And we often think of informal institutions as the problem. But we should recognize that there are also institutions that are congruent with formal democratic rules that make them work, that fill in the gaps. Anyway, the premises are three, really. One is that no democracy can protect itself, even the ones we think of as sort of militant democracies that sometimes create laws that will protect themselves from illiberal behavior. But every democracy is necessarily under-institutionalized and depends on informal institutions and political protections as much as it depends on legal protections. And so for that reason, formal institutions aren't always capable of drawing the line between what's democratic and what's autocratic. And for that reason, then, legality is not the end of the discussion. If someone defends their practices because they're legal, we can still ask whether those behaviors, whether those practices advance or detract from the core elements of democracy. And that should be obvious. But there's a sort of double problem, which is that in addition to that, those practices are often defended as an expression of one version of democracy, which is sort of the popular support version of democracy. So sometimes we have very popular leaders who say, well, A, it's legal, and B, the people want it, and therefore it must be both legal and democratic. And we want to say, no, actually, there are lots of practices in democracies that are truly problematic, that we should call autocratic legalism, even if they're legal and even if people support them, even if lots of people like them. So the four practices I've listed here, I'm going to go through them in order, and hopefully we'll get to the questions and answers shortly. So anyway, the four practices are these. Well, one is this dismantling of the informal norms that supported democracy over time. The other one is something that happens from the top, often from the executive, which is the hollowing out of enforcement mechanisms. The third one is often the province of the judiciary, which is this sort of creation of new revisionist, strained, opportunistic interpretations of existing rules. And the fourth is what we've seen in lots of countries, which is now we're going to take the step of sort of formally amending our institutional framework to detract from its democratic features. So let me go through these in order. One of the things that hopefully I can convince you of today is that in any democracy, there's thousands and thousands of practices that bear on the nature of the regime, right? That bear on whether a regime is democratic or not. And depending on what the outcome is of those practices, the regime is maybe made a little more democratic or a little less democratic, a little more autocratic. And in this sort of, for purposes of this discussion, we're just posing those two concepts as the opposite poles on a continuum, right? So if the primary normative justification for a practice is formal, like, well, we're holding an election because the law requires us to hold an election, and the outcome is more likely to be democratic, then we think of that as being one of the core sort of democratic practices in that regime. But as I was mentioning, there are lots of practices that aren't formally required or forbidden, but that actually make the system more democratic. These practices follow sort of congruent democratic norms, but don't necessarily respond to law. And when people say, why are you doing this? They might point to a longstanding norm, either a social norm or a political norm, some informal institution of that sort. And then on the bottom row, we have sort of autocratic behaviors, behaviors where the outcome is likely to be more autocratic. And if they violate the formal democratic rules, then we think of them as transgressive practices. They're breaking the norm, right? A president who overstays after losing an election is transgressing the formal rules and is creating a more sort of autocratic system. And then at the informal level, what we see in sort of formally institutionalized democracies, but we see leaders who are behaving more autocratically, but perhaps without breaking the rules, but violating these longstanding norms, as that article was describing. So, the second practice is this idea that leaders often, when they're embarked on this journey toward autocracy, they will strip civil rights mechanisms of their enforcement power. They'll weaken the courts through appointments and rebudgeting. I'm going to go quickly through this. And then along the way, they will sometimes, or maybe even after capturing these enforcement institutions through these mechanisms, they will use revisionist interpretations to weaken democratic laws and institutions. So often the first step toward a reinterpretation of the Constitution is the capture of the courts, and then the second step is the court beginning to erode democracy from within by interpreting away or by refusing to enforce different legal provisions that protect democracy. And then sort of the last step along the path is this is the step that many countries have taken, which is to either create an entirely new constitutional framework. We've seen that happen in many countries, but maybe less noticeable is something that I see happening all over in the US, which is these sort of baby steps toward less democracy through formal institutional changes, right? So I mentioned earlier, in Texas, voting rights. We're in the middle of this major legislative battle in Texas right now. The Democrats are in hiding outside of Texas, trying to deny Republicans a quorum because that's the only way they can stop the legislation from happening. The House of Representatives has issued arrest warrants for the Democratic legislators who are missing, and they're trying to bring them back so they can vote in a series of changes to our voting rules that will make it harder for people to vote. And I think, well, my interpretation, which they would deny, obviously, is that they hope that these new restrictions fall disproportionately on people who tend to support the Democrats. And those tend to be sort of people of color, Black people in the big cities, and Hispanics in the sort of southern part of Texas. So we see this happening. I don't know if you saw anyway, I'm getting weird messages from Zoom that says, now you can see my screen. Well, hopefully you've been seeing some of it. Anyway, the only slide you really need to see today is this next one, right? So how does this all work together? How does this package of concepts and practices and premises sort of add up to a coherent story about the movement from democracy to autocracy, the movement we've been seeing in different countries over the course of the last few years? And I think we can sort of array regimes on this continuum from sort of strongly institutionalized democracies that have a robust legal framework for practicing democracy, for protecting people who are trying to exercise their rights. And we have a set of sort of weakly institutionalized democracies, which are often supported by strong informal institutions, right? So that's the reason the article in the New York Times sounded so shocked about what was happening in the UK is that they expected that their informal institutions would work would work to protect the system. And the same is true in the US, right? So for if you've read the book by Steve Levitsky and Dan Ziblatt, you'll see that they put a lot of weight on what they call the guardrails of democracy, or a set of informal norms that protected the system. And I think that's more likely to be the case in older democracies. But I think, as I said earlier, that's true everywhere. Then as we sort of move across the continuum, we find illiberal democracies where the illiberal practices have become part of the normative framework, right? They're not formally institutionalized, but there are a set of illiberal, informal institutions that make the system less democratic. And then as we move further, we get to the systems that are actually fully institutionalized as autocracies. So yes, so let me run quickly through this then. And then, so in each of these boxes, and this may be a temporal thing, but different things may be going on. We may be seeing the same practices different practices at the same time in the same country, right? So sometimes, we may see weak rules that don't really extend to many democratic practices, and then autocratic practices coming in to fill the void, but not completely destroying the democratic nature of the system. And then some autocratic practices slowly beginning to turn into norms and more directly challenging the democratic practices that we see. And then ultimately, really sort of a slide into autocracy later on in the system. And the practices that we see kind of have a role to play at different steps in this process, right? So this is fairly a straightforward interpretation of the 2x2 table I showed you earlier. We just spread it out across the across that path. But then you can see that when you're hollowing out enforcement institutions, that makes it easier to go from an informally institutionalized illiberal democracy into a more informally institutionalized autocracy. In other words, the practices that would be violating democratic norms are not punished or are not rooted out because the enforcement institutions have been hollowed out. And then over time, then revisionist interpretations not only step in to make those practices actually legal, but then they start to create a whole new framework for autocratic practices. And actually what we think of as sort of the legal reforms that are the basis often for a movement into autocracy, those legal reforms really only have a role to play in a couple different places in this process. First, in taking away some of the formal institutional protections of democracy to open up space for sort of more transgressive practices or more informal practices that can violate the norms. And then at the very tail end of the process, in actually formalizing an autocratic system that has been sort of created through legal practices all along. So I'll stop there. I'm really sorry that this was so interrupted and so disrupted, but hopefully we'll have an interesting conversation going on.
Welcome everyone here physically and also digitally. And first of all, thanks Dan for this amazing keynote. I think it will prove very useful for our coming discussion, which I will start shortly. But first, there are some things to go through. First, I would like to introduce our amazing panel. Of course, we have Dan Brinks, who we met already. Then we have Conrado Mendes from Brazil, who is a professor of constitutional law at the University of Sao Paulo. Then again on Zoom, Roberto Gargarella from the University of Buenos Aires, Argentina. And I think our final panelist on Zoom is Maria Popova. Welcome all of you. Maria is associate professor at the McGill University from Canada. And here with me today physically are first Eirik Holmøyvik, who is a professor of law at the University of Bergen and also substitute member at the Venice Commission. And then we have Gökhan, who is my colleague here at LawTransform and also senior legal researcher at CMI and UIB. And also I would just like to let our audience know that during the last 10 minutes of this session, we will open up for questions, both from the digital audience and the physical audience here. So don't keep any questions within yourself, please. And also this session is recorded and will stay on YouTube. So if it's a problem for anyone, please let us know. And I think now it's time to proceed to our roundtable session, which the aim here would be is to kind of show through different regions, different regime types, how these abusive legal practices play out through a variety of different routes, and but basically achieving similar goals and results. So first, I would like to give the word to Conrado Mendes, and after Dan's amazing kind of theoretical foundation, I would like to ask you to please put us into context and explain and tell us how, for example, autocratic legalism plays out within a certain country, in your country of expertise, Brazil. For example, how Brazil is on this path to formally institutionalized autocracy. Please, the word is yours, Conrado.
It's my turn? Okay. Thank you, Dan. Thank you, Siri, for the invitation. It's nice to see you all here. I think I would like to start by raising a more conceptual point of the project, and because we call it autocratic legalism. And it's interesting and important for us to unpack or to explore a little bit what we call by legalism. And I think that Dan's presentation made it very clear in a very precise way, all the dimensions we are taking on board in terms of the practices of this autocratization handbook, and also the legal path toward autocratization. And there is a distinction that is fundamental in this project, which is this interdependence and mutual reinforcement of the formal and informal side of the rule of law and democracy. And we have the perception that the informal side of the rule of law is underappreciated or underperceived right now in the literature, but traditionally in the more theoretical discussion about the rule of law. What I wanted to raise, and it's something that I've been thinking about, is that there is another distinction that perhaps we are still not drawing and not paying too much attention. And I'm afraid this distinction lies within what we call formal, which is the distinction between strictly procedural and formalistic legalism and more substantive legalism. So sometimes we take for granted that what is happening is legally valid. The example that Dan brought us in the introduction of his talk about the New York Times op-ed, basically claiming that no rules were broken, everything was being done within the law, there was nothing wrong going on. and perhaps this is a notion of legalism that is in itself problematic. Sometimes you take for granted that is legally valid, but often it is not legal through more substantive lenses. So there is a gap between, and perhaps there is an assumption that within this concept of legalism and autocratic legalism, that from a very formalistic point of view, nothing is being done wrongly. But from very basic rules of many constitutions, actually, it is hard to conceive those things as legally valid. So we don't need even any demanding notion of the spirit of the law to find that is not actually proper legalism. It's basically transgressing openly the letter of the law. So in most constitutions, we basically need some of the substantive principles they openly endorse to show that this is not exactly doing everything within the law. It is not within the law. If we adopt very basic notions of separation of powers, judicial independence, pluralism, equality, we can see that what is happening in those places. And then part of the literature is called, it has been calling legalism. That is actually basically infringing the law, and not infringing informal rules, basically infringing substantive legal principles. When I see Polish and Hungarian ways of packing the courts, I find it hard to call that, to use the word legalism as if it was everything going correctly. Perhaps they were not, and even if obeying very, very basic procedural rules of constitutional amendments, that is a notion of legalism that is not taken too seriously. This is an old discussion of constitutional doctrine as well. How much you can amend the constitution for that amendment to be valid, etc. So I'm basically trying to problematize the notion of legalism, because I think the very concept, and I have this unease with the expression, with the very important and groundbreaking paper that Kim Shapley, for example, which is a reference for us as well, has written. I think there is a underestimated or under-conceptualized notion of legalism, which does not consider that within legalism itself there is a dignity, and that is not being followed by those handbooks. But I'll stop here. Thank you, Dan. I'm not sure I talked too much. I didn't know how much I had to talk.
No, it's great, and I think it was a bit different start than where I wanted to start, but I think we are off to a really good start. And if any of the panel wants to drop in, you can put up your hand. Yeah, okay, Roberto, please.
Yeah, thank you. No, first to say I'm very happy to participate in this discussion. I'm also very honored. And I think that Dan's presentation was great, and I think that also Conrado's point was right. I wanted to follow a little bit, but I just want to stress that I see this as a super important discussion. And Conrado problematized a little the notion of the legalism. I want to say something against the autocratic part, and also then something about the legalist part. About autocratic, well, I wouldn't say that at least the picture, the panorama that we see in Latin America and in other countries, is not generally that we are going there, or that's the near future, no, like Venezuela or Hungary. That's possible, and that's right that Dan was mentioning those cases, but those are extremes that I don't think most of our countries will get there. And I think that, so in that sense, it makes more sense to think about the kind of hybrid regimes where, I mean, many other people like the same Levitsky have been thinking about it. So we are there in this kind of hybrid regimes or degraded democracies, and so we have to think about this kind of very problematic hybrid regime, which cannot be defined as democratic, but also cannot be defined or shouldn't be defined as autocratic. And again, it's not the near future for most of us, but this hybrid is very problematic. So that's concerning the autocratic. Concerning the legalistic part, I think that, again, that we are in something that is in the middle or somewhere in between. And in that sense, I want to make a more substantive point, which is that what part of the doctrine, like Ginsburg et al., have been mentioning as a kind of novelty, or the eroded democracies, or the, I think in Latin America is a very old problem, and so which now is not expressed through the form of military coups or recurrent, permanent, persistent military coup, but it's an old problem, and the old problem is that we, from the very beginning, and that's what comes at least from what I studied in Latin American constitutionalism, we have tried with a particular understanding of the system of checks and balances, which is creating and is a source of part of the problem. Of course, not all the problems have the source in the constitution, but there is at least this we need to mention, which is that at least an important part comes from there. And I think that from the very beginning, I would say, because of the peculiar way in which the main political groups made their basic social pact or constitutional pact, and the peculiar way in which they combine their initiatives, they created this very problematic animal, which is I would call an unbalanced system of checks and balances. So liberals wanted something like the US model, so a system of checks and balances. Conservatives wanted something more like the monarchical regimes. And the most typical form that we created in most countries in the 19th century was the combination of both things at the same time. What liberals wanted, something like a checks and balances, and what conservatives wanted, which is something more like a monarchical system. So we have a system of checks and balance, and in the top we have a very strong executive power, which distorted the whole thing, because the whole idea of having a system of checks and balance was to have a system of mutual equilibrium. So all the different branches, as James Madison was saying, had to have the power to interfere or to threat the other branch and to have equivalent powers. But when you have one of the branches that is much more powerful than the others, so you distort the equilibrium from the very beginning. So that's what we have from the very beginning. And in a way, it's no surprise, this degradation of the system of checks and balance comes from the minute one. So for part of the doctrine in political science, so typical in Ginsburg work, excellent work. So the idea is, well, after the 11th of September, things start changing. The executive got more powers, but that's a 200th century problem in Latin America. That's what we have from the very first minute. So we are living with this problem, which now is not expressed with a military coup, and we have to think why. And that's, I think there are some answers about that. But we have installed this kind of peculiar and very problematic system from the very beginning. So that would be the substantive point. Now, from what is coming, I think that in a way, the hope is that the forces for challenging what we have are still intact in most countries. That's what we see. In a way, the force for destruction, as we can see in Colombia, so for example, or in Chile, well, they are there. So it's possible, and Latin American societies are enough mobilized, so we can expect people, Brazil in a way, to stand up and start protesting, challenging, etc. My concern is that the force for construction, and even more worrisome, to construct something that becomes stable, that's very difficult, because from a very unequal society, organization, institution, constitution that has been there for ages, for centuries, it's very difficult to bring from there a stable, more egalitarian order. So what to do is difficult. I think part of the story, part of the solution has to do with repair the institutions, but again, the conditions are not the best. And there is something interesting to check around, which is the essays we already have in changing our constitutions. I think that what we did in the end of the 20th century was not very interesting in Ecuador, in Venezuela, in Bolivia. And my guess is that even though the forces and the composition now in Chile are very interesting, my guess is that we are not going to get something innovative in the parts we need to really repair. So what to do? I think that at least we need to put the light on where the problems is, because I think we are reading wrongly what is happening. So when we see the kind of answers we got from constitutional reformers in all the region, we see that they are not paying attention to the problem properly. They are not understanding where the problem relies. So for example, one common answer to increase more and more and more the list of fundamental rights with social rights, that's fine, but that's not a solution at all if we don't pay attention to the engine room or things like that. But not only we need to go to the organization of powers, we need to do certain things in the organization of powers. It's not just to put the hands there, but what to do. And so we have to repair the machine in the right direction. That takes us to discuss more about democracy, and there I would like to engage in the future with Dan, but we can leave that for later. So.
Yeah, thank you, Roberto. I was actually wondering, Maria, if you could take us further how what Roberto has been saying from his own experience, if it's also reflected in your research, and you already have your own concept of weaponized legalism, and also its relation to autocratic legalism. So I think we could maybe take the discussion a bit into that direction now.
Yeah, thank you very much, Alida. Thank you, Siri, for inviting me to this super interesting event. And thanks, Dan, for jumpstarting this incredibly interesting discussion. I come to this discussion as someone who is not part of this project on autocratic legalism, but as someone who has also thought about these processes and how exactly to conceptualize them. And I think our conceptualization actually has a lot of overlap, but the direction that I want to push you on is very similar to the direction that Roberto just talked about, sort of to push you on the autocratic part. And as Alida mentioned, I've started proposing this term weaponized legalism, and there is significant overlap with autocratic legalism in the practices, in the phenomena that we observe. They're part of so there's overlap between the two, definitely in this abusive use of the legal process to achieve political goals, in trying to continuously reform the judiciary in ways that are useful to the political actors that are trying to achieve these goals. So what I call weaponized legalism is basically starts from the idea that actors mobilize the law purely for political instrumental goals, to undermine their political opponents, to protect or to boost their political partners. They try to utilize court decisions that go in their favor to signal strength and power politically. So this politicization of the legal process that happens in bad faith for instrumental reasons rather than for ideological reasons, I call the weaponization of the law. And when weaponization becomes a dominant strategy of political competition, when it's frequently used by actors across the political spectrum, I think we can talk about this hybrid situation that Roberto referred to. We can talk about the rise of this weaponized legalism regime, where the law can be used or misused, but is used for political goals. Now, the strategies of weaponized legalism are indeed very similar to the strategies that you describe as within autocratic legalism, sort of, different types of strategies that are used to influence the courts and their decisions. They can be reactive strategies, proactive strategies, they can be ad hoc, or systematic, they can be formal or informal. So there's significant overlap there. But where the difference lies to me is that autocratic legalism, as you defined it, has this teleological assumption within it that both the practices and the goals of the drivers of autocratic legalism, the aim there is to produce eventually an authoritarian regime. And even if that's not the aim per se, this legal path that you defined, Dan, is sort of this idea that inexorably in some ways, there will be movement towards autocratic consolidation. And the weaponized legalism lens, by contrast, can be more agnostic about regime goals or regime effects. Basically recognizing, for example, that oftentimes political actors can engage in these strategies and practices, even when they have very limited short-term goals of using or abusing the law for immediate political gain, without any longer-term or broader goals of undermining democratic political competition. These actors may lack authoritarian ambition. They may even be ideologically, or think they are ideologically committed to democracy. And actually, I'm increasingly seeing some examples from the post-communist region where even democratizing actors may engage in weaponized legalism. To give you an example here, we have the Ukrainian president who is trying to pack the constitutional court following the typical autocratic legalism playbook. But the reason he wants to do this is he's doing it in response to the constitutional court overtly undermining his attempts to tackle political corruption. The constitutional court revealed itself as very much a retrograde, in fact, defender of autocratic actors. So a democratizing agent is trying to weaponize the law or has done it already. So within the weaponized legalism framework, this is it's possible to accommodate, to recognize that these are the same uses of these tools and these practices and strategies, but to different effects. And because of that, weaponized legalism really can be a very durable legal regime of a legal regime that's often associated with a dysfunctional but still competitive democracy. The identity of the weaponizer changes over time, but politicized courts that are used to shape political competition outcomes remain the norm. So it can be a durable arrangement that doesn't really lead in the direction of democratic backsliding and complete democratic disintegration, but it is nonetheless highly problematic from the point of view of the rule of law, but also indirectly could be responsible for undermining democracy through eroding public trust in institutions, because the long-term effects of a weaponized legalism regime is that trust in the courts, in the judiciary, is likely going to decrease, and that makes actually these regimes more susceptible to then autocratic legalism, should that actually be the goal of major political actors. So I know Alida also wanted me to address a little bit the post-communist cases, and Conrado already alluded to Poland and Hungary as these cases. And what I wanted to point out about the post-communist cases, are they more vulnerable to autocratic legalism or weaponized legalism? And I think they are, but not necessarily because they're newer democracies, which is kind of what the easy answer has been. Well, they're new, they're under consolidated, and that's why they crumbled so quickly. I think actually the root is more specific than that. And the root is really the state capture by oligarchic interests, which happened during the transition across the region, and which produced really low trust in institutions. Compounded to that, the judiciary's inaction, impotence to reveal or to stop state capture has resulted in dismally low trust in courts across the region. Added to that, we have the EU accession process, during which post-communist countries went through crazy, hectic institutional creation in a whole variety of areas with very little public debate, mandated institutional creation. And the result of both of these specific post-communist realities is that autocratic legalist practices and weaponized legalism practices have much lower political costs in this context, and that's why these regimes are more vulnerable to them. It's just very easy to sell to the post-communist voter that the judiciary needs to be fundamentally transformed to be made to function better. It is a much tougher sell to do this in the US, to pack the court, not necessarily because of time simply, but because trust in the judiciary is higher. So I think this is what makes the post-communist countries particularly sort of fertile testing ground for these strategies of using the courts in different ways for political purposes, because the courts are simply not endowed with the same trust and legitimacy as in other more consolidated contexts. So I'll stop there. Thank you.
Yeah, thanks, Marianne. It was amazing, but I think it also makes all this all the more problematic, because based on what you said about weaponized legalism, it's basically the weaponization of law is used by all parties. For example, in Hungary, some of the parties proposed that if they win the election next year, they would like to create a new constitution, even with a simple majority. So I think, yeah, you might say that the goal or the effect would be different, but it also makes the task of separating autocratic practices from illegal acts of state power all the more difficult. But maybe Gökhan could help us out with that.
Yeah, well, I may firstly cite the one seminal definition of autocratic legalism, which says that there are three elements in that: the use, abuse, and non-use of the law for authoritarian purposes. When you take these elements separately, they're not new. They're all 200 years old discussions. The use of law means a law, formally valid law, having an authoritarian content. So we can discuss it within the context of natural law theories, or inclusive positivist law theories, or law relationship between the political morality, etc. The abuse of law here, from the outset, the law looks okay, but the interpretation, judicial interpretation, and oral interpretation in most cases, particularly pro-government judges, interpret these laws to support the interests of the government, the authoritarian government. And non-use of law is blatantly illegal act of state power. So if you take it separately, these discussions, you may subsume them into some sort of legalistic, legitimacy, natural law, positivist law, etc. discussions. But I think what makes them new is this weird combination of these three aspects in every given state. So then I may refer to Dan's keynote speech here. Then we see this from a neo-institutionalist point of view, that the rational actors who wants to carry on their authoritarian projects use them and mold the institutional state of given each political regime. One example is, for example, all contemporary autocratic legalism does is the case of omnibus bills. Like there are insignificant laws, or there are good laws, but they're not enforceable, so they don't serve for anything. 25 articles of good laws, and there's one hidden bad law just in the middle of nowhere. So you cannot detect it as a political actor. You cannot go to as a concrete control to the Constitutional Court before the deadline passes, because it's hidden somewhere, and you just realize it after it's been used. It's a very common aspects of the authoritarian leaders' strategy, which ironically, which was prohibited by Roman law before Christ in 98. That's a single subject rule. In the Senate, in the legislation, you cannot put a bunch of unrelated laws into one package and then bedazzle the legislators, force them to apply it. It is one example of a conceptual or a technical way of, formal way of defining an autocratic legalist approach. If I want to study a country from perspective of what we have been talking as autocratic legalism, I would put a three-test approach, and they may seem, again, when looked at separately, they may seem very old approaches. First is detecting the blatantly illegal content, like in the Kelsenian sense, if it is against the constitution or against the higher norms. The second is legislation is good, but interpretation is bad. So we have to look at the arguments of the courts, the interpreting agents. The third one is the most tricky one. The legislation is good, interpretation and application is legitimate, But there's a problem here, which we call either there's an ulterior motive, an ulterior aim to be reached by that application of that law, or a long-standing constitutional convention, which is also defined as by some of you as informal rules, etc. Long-standing constitutional democratic conventions are ignored. So this third one is the most tricky one. The third one should be analyzed comparatively in order for us to counter-argue as lawyer if someday we are faced with an autocrat in the court. We cannot really analyze, not synthesize the normative arguments for now, but at least if we analyze them comparatively, and see the patterns in here, we can be more adept to create the necessary normative arguments. The ulterior motive, the aim is also tricky. It is a new thing, particularly in this region in Europe, in European Convention of Human Rights. The European Court of Human Rights has been creating and developing a new jurisprudence based on the Convention's Article 18, which says that the state should not restrict the freedoms by basing on the motives that are not listed in the relevant section, which gives that the applying one law to reach an irrelevant aim is becoming more and more normatively challenged. Example is like A is a prominent anti-government activist, and the police stops him or her on the way to giving a speech in a very important rally, just to make a ID control. So the court now giving the decisions about that, basing on the context, the states are using the legitimate ways to reach legitimate aims. I think another thing that we have to consider is to compare the modern autocratizations, which appear mostly in the case of populist regimes, by contrasting the old authoritarian systems having thick ideologies, or Roberto was mentioning that the conservative constitutionalism or authoritarian constitutionalism, in the sense that there's an abstraction of state or community which should be protected at all costs, particularly as opposed to individual human rights. That is, populism and authoritarianism overlaps in the sense that it has an inherent authoritarian ideology or way of life, and instrumentalist, manipulative use of law. But the difference between the traditional authoritarianism is also traditional autocratic legalism, which we may trace back to 19th century Germany, saying that it is elitist, and it aims to depoliticize the society, and there is a sort of abstraction of the state. So we also have to make the difference between new autocratization, which is revealed in most of the cases in the populist settings, and divide them or discern them from old authoritarianism. I think, it's for now. I can elaborate.
And I think this also takes us a bit back to where we started in the beginning as well, how formal institutions are not really enough, and how these informal democratic norms are basically the ones that can keep up the system, but functioning together with the formal framework. But I was wondering that, Eirik, you are coming from Norway, which is kind of a very democratic country, you could say. And I remember that we had a conversation about that once, that Norway is an interesting example, because you really heavily rely on democratic informal norms to keep the system going, because you kind of have maybe a weaker formal round around it that can protect it. And I was wondering if maybe there is something that should be changed based on what you have been hearing, or maybe if you think that could be a danger, that of course we say that these informalities should be protected. I don't know, maybe by putting it into law or by formalizing it, I don't know. but also if you feel that Norway or countries that are now democratic maybe should do something to make it that way based on these examples that we've been hearing.
Yes, well, thank you, and thank you all for all the introduction to Dan and for all the interventions. As for Norway, well, we have a constitution that is very short, quite obscure, and it is completely lacking on many important issues like government formation and so on. So we are highly dependent on these, what we can call this democratic culture that is very, very strong. And there is a genuine sense of cooperation, for example, in the parliament between the different parties and different factions. Of course, in Norway too, we suffer from time to time from what we may call, weaponized legalism. Just recently, this year, we had a Supreme Court decision on an advisory opinion where the Supreme Court approved the majority's interpretation of the Constitution, which basically abolished a minority right written into the Constitution, a crystal clear provision in the Constitution providing minority protection with a qualified majority decision for transferring powers to international organization. And the court just simply said the majority, a simple majority, is sufficient to decide whether or not the minority can exercise their rights. So this provision is now just null and void, basically. And in Norway, this was considered as the government and the political parties apply the same arguments as you see in countries which suffers from autocratic legalism. They said, well, I mean, the parliament has done this so much, so many times, and there's a majority behind it. This is the will of the elected representatives of the people. This is the will of the majority. So a minority should not be able to stop this politics. And this is exactly the same argument as we see in Poland and in other countries where you see this autocratic legalism. So I'm not sure if there's a great difference between weaponized legalism and autocratic legalism, as is understood in the project that Dan presented, because that is basically a gliding scale, and you don't know the autocratic outcome in the beginning. And this attitude where that a majority of representing the people can set aside also informal norms, which allows the opposition to perform its part in a democracy. This has been recognized by the Council of Europe in a number of documents. It's called the winner takes it all mentality, and it is really behind these legal reforms. And I also work for the Council of Europe, reviewing a number of legal reforms in Europe. And the number one complaint, the first thing we look for is basically the quality of the legislative process. Where is the opposition in this? And more often than not, well, the opposition is not there. We see rushed legislation all over the place. We see omnibus bills that Gökhan mentioned, and we see a truckload of bills introduced in the same day. So, for example, in Ukraine a few years ago, or 1 year ago, the president introduced 100 bills in one day to the parliament, and one of them included the termination of the powers of the judges of the Supreme Court, all of them. So, I mean, and it's very hard for the parliament to exercise their rights and their role in a democracy when you have this kind of legislative techniques. And even though you stay within the confines of the Constitution, because you stay within the minimum rules, but you don't allow the deliberative democratic process to play out. So, and we see this also in Norway, but this is really, really prevalent in the countries which, for example, the Mendes Commission is frequently active in. For example, Ukraine, we've seen it in Moldova, we see this in Poland now, and in a number of countries. For example, another example out of many, in Bulgaria last year, the government proposed a complete revision of the constitution with drastic measures, for example, reducing the members of parliaments by 50%. And they introduced this in a complete surprise without any impact assessments, any preparation at all. They just bombed it into parliament. And there's no way you can have a functioning democracy with such an approach to legislation. So I think just one more thing. I will just add to what Conrado said about the very concept of legalism. In Europe, we do have a more substantive concept of legalism, thanks to the fact that we have two supranational legal systems, the European Convention of Human Rights, mentioned also by Gökhan, and the EU law. And in both those systems, legalism is a substantive concept. So even short of the Article 18 cases, which Gökhan mentioned, according to the case law of the European Court of Human Rights, any right, even political rights of the oppositions, need to be practical and effective, not only formal. And that is that's a legal argument, which means that laws that are that violates these rights, they keep them formally, but that renders them ineffective, they will not be legal according to the European Convention of Human Rights. I think I'll stop there.
Yeah, and I think in this case, the pandemic also didn't help with all these emergency powers to the executive that basically gave them free power to push to degrees and rule through degrees without necessary negotiations with the other parties within the parliament. But now, then, I think we have one question, so I will let you see that. So looking at that question and kind of also, if you could reflect on the others. So we heard about weak institutions. We try to find ideas of how to protect these weak institutions. Would it be by a legal tool? But then we have problems with everyone weaponizing the law and kind of for using it in whichever way they see fitting to their own goals. And then we have, it seems, this democratic culture or informal norms that are trying to keep the system together. And there is also the question: what happens if these informal norms already lost their democratic content? And does it mean the path of point of no return? So if you could kindly reflect on what has been said so far. Just a small topic.
Right. Just right. So a really interesting point. So I mean, and it would really take way too long to respond to everyone. I mean, I think Conrado is right. You know, in that we too easily let people get away with claiming that something is legal, and we don't push back, and we don't think about sort of the substantive issues in that. But I think that sort of becomes also part of the problem. This thin notion of legalism is often what allows, you know, justices on Supreme Courts, like in the US, to come up with interpretations of a constitution that, while maybe textually could be justified, even though, well, sometimes they can't, but you know, but they are not sort of paying attention to that fundamental notion of sort of dignity or the fundamental values of the regime, and in their interpretation as an interpretive principle, right? So the interpretive tools that they have don't incorporate these more substantive notions, and I think that's part of the problem. And that's, I think, really connects closely to what Maria was talking about earlier as well. So I would say, you know, I I didn't mean to present, I know it looks that way because I have like arrows and everything lined up and numbered from 1 to 5 or something. But I don't mean to suggest, right, that once you're sort of on this slippery slope down to autocratic, fully institutionalized regimes, that you've kind of stepped on the banana peel and next thing you know, that's where you are. I would say these are, the way I think of this in a way is that, you know, there, as I said earlier, tens of thousands of small, tiny practices that add up, and then some really big ones, right? And lots of small ones that add up to making a regime more inclusive or less inclusive, right? More participatory or less participatory. And that, I think, is what I'm thinking about, this kind of piecemeal erosion of those things that pushes through legal practices, that pushes a regime more in one direction or another. And that, I think, is the big difference between, I think you're right, Maria, to highlight the differences between what we've called autocratic legalism and what you've called weaponized legalism. I agree. And as you were talking about the sort of case of Ukraine, I was thinking also of the case of Chile, which I think it was 2005, there was a similar attempt to sort of democratize the constitutional court by expanding it, adding a bunch of people who weren't so closely tied to the previous regime and really conservative factions in society and so on, right? And some people criticize that as packing the court. And others defended it as a way to make the court more attuned to the current sort of democratic political system. And I think, you know, I guess I'm a little, it's in some ways sort of I have always in the back of my head the idea that law is always weaponized. I mean, we're always using law to achieve something. And the question is, you know, where does the problem come in, right? And so for us in this project, we decided, well, the problem, the line we want to worry about crossing is the line that goes from not just using law for instrumental purposes, which we all do, right? I mean, if you want to improve women's equality, then you pass laws to do that, right? But the line we were worried about crossing was the line between sort of making a regime more autocratic and not, right? And so I think I think you're right. I think you're right to call attention to the increasing use of weaponized legalism, because I do think it's a problem, and I do think it has consequences, even if you have nothing but the purest of intentions, right? It erodes trust in institutions. It erodes the rule of law. Right, it lends itself to strained and untenable interpretations of legal texts, right? It has a whole bunch of consequences that I think are negative, even if it doesn't ultimately take you in a more autocratic direction. But I think we need to think about these two things as maybe a little bit separate things. So, and the other thing I was thinking of was when Roberto says, you know, suddenly people who focus on the US think, oh no, here's this new phenomenon that we've never seen in the history of the world. And it turns out, right, that it's been happening for a long time in a lot of places. So I was thinking about that. So why is that, right? Why is it that the US and the UK and various countries in Europe and other countries that we always thought had reasonably strong institutions, and we always thought had this reasonably strong democratic culture, this reasonably strong set of norms that protected the democratic system. Why is it that seems to be crumbling in some places and not in others? And why is it that it's always been weak in some places? And in this sense, I do think, you know, we spent quite a bit of time thinking about why some places have perpetually weak institutions in a recent project with Steve Levitsky and Maria Victoria Murillo. And, you know, we sort of said, well, institutional strength is given by the strength of the coalitions that support a particular institution, right? And there's always somebody who is opposed, and there's always somebody who's in support. And so if these things are weakening now, then it must be because those coalitions are shifting and changing. And I think what happened in places like the UK or in the US is that there was always a cross-partisan coalition of support for the actual institutions themselves, right? And that's what we didn't have in the post-communist regimes. That's what we didn't really have in many Latin American countries, because the institutions weren't seen as benefiting everyone. They were seen as benefiting a particular group, right? And so when that sort of cross-partisan coalition of support falls apart, that's when the institutions are really vulnerable.
Done.
Undermined. Yeah.
I think I'm really sorry, everyone.
Are we running out of time? We're running out of time, I'm sure.
We have to stop it here, but yeah, I heard that it's best to stop, and everyone is really engaged and wants to discuss more, because that it means that it was a good event. So I just want to thank you all, and I'm really looking forward to hearing more of this discussion and how it evolves. And also for our audience, a really quick comment. If you probably realize that we missed a whole continent. So please, our next event will focus wholly on Africa, with an amazing panel starting in 13 minutes. So thanks for being here.